My name is Harold Takooshian at Fordham University in New York. I'm with Professor Robert Emmons, and for the past 39 years, every Friday night, we've been giving a course in law and psychology, and the school kindly let us give it in person this year in spite of the dire conditions in New York. In fact, it's the only psychology course being given in person at Lincoln Center. And part of the law and psychology seminar, which is attended by seniors, is to look at how psychology can benefit the legal system in the United States. What a pleasure it is tonight to have a special session that's international with Jeffrey Descovich here in New York City and Fabian Commando. Did I pronounce it right, Fabian?
Fabian Commando.
Who is an attorney in Argentina who has taken it as part of his mission in life to undo wrongful convictions. And the third speaker is Dalton in Newfoundland, Canada, who had a tragedy, but emerged from it stronger and is now very active in the Innocence Canada project. Let me focus on Jeffrey Descovich. And Bob is not in a great position to make comments, but he's a little bit visible in one of the screens there. Do you have anything to add, Bob, before I continue?
No, just thank you all for being here today. We know, Jeffrey, welcome again. And it's always wonderful to have you participate in the class, and look forward to another lively discussion on important issues.
And there will be time afterwards for discussion. This session is co-sponsored by several organizations, including the American Psych Association and the Psychology Coalition at the UN. We wanted to have an international session this year. Let me introduce Jeffrey Descovich and then keep quiet. And Bob will be the moderator later on in the session when the three speakers have concluded. Let me say that back in 2014, Jeffrey Descovich first came to Fordham to speak about wrongful convictions. And it was a remarkable session, just so powerful. And every year he has come back since then. And this year he said, why not make it international? Why not invite colleagues from other countries? Mr. Descovich was a youngster, really a teenager, back in the 1980s when one of his friends was killed. A 16-year-old woman was killed. And somehow Jeffrey Descovich became caught between the polygraph and the police and investigations. And a helpful 16-year-old was sent to jail. And he spent many years in jail, but all the while protesting his guilt. He even appealed to the Supreme Court. And one of the people who assisted him, at least at that time, was Governor Cuomo, who was then a candidate for governor. What Governor Cuomo has done since then is not clear. But Jeffrey Descovich never gave up. Even the Innocence Project here in New York City initially did not take his case until a particular individual, Claudia Whitman, intervened and just turned everything around. Jeffrey was fully exonerated back in the year 2008. And what a noble human being he is to take this as his cause and form the Jeffrey Descovich Foundation, which in turn has been helpful in making more exonerees, more people who were convicted. Many of us think of the US legal system as a model for other countries. And yet we know from the Innocence Project that it makes mistakes and it could be improved. And Mr. Descovich went on to law school to earn his law degree so that he could be more effective in helping other people who are wrongly convicted like he was. He received a large settlement because of his wrongful conviction, and he has rechanneled that into helping other people. So let me turn it over to Mr. Descovich to tell you more about himself and his cause, and to eventually introduce his two colleagues. Thank you.
Thank you, Dr. Takooshian. So I was wrongfully convicted in 1990 of a murder and rape, which I did not commit. I was 16 years old when I was arrested. It was in the Westchester County, New York, which is the suburbs. It was an ethnically diverse city, and it was middle class. So my wrongful conviction was caused by, at age 17, was caused by a coerced false confession, prosecutorial misconduct, fraud by the medical examiner, terrible public defender. Let me unpack that a little bit. Most people think that an innocent person would never confess to something that they didn't do. Yet it's been the cause of wrongful conviction in 25% of the DNA-proven wrongful convictions, with particularly vulnerable populations as having been identified by false confession experts as youth and people with mental health issues. In terms of my false confession, as background, you should know that I came from a single parent household. My father was never involved in my life in any capacity. And that directly intersected with the good cop, bad cop technique, in which one officer takes on a more aggressive role, whereas his partner pretends to be opposed to what's going on, yet somehow powerless to intervene. With the purpose of this tactic, of course, being that when the suspect becomes frightened, of course, they'd look to a friendly face for assistance. And I began to look up to that officer who was pretending to be my friend as a father figure. Prior to being a teenager, the career that I wanted to have when I grew up was I wanted to be a cop. And so that also intersected with one of the tactics the cops did, in which, so every time I interacted with them, the interaction took on the following dynamic. That half the time they would speak to me as if I was a suspect, and then when they would push too hard and I'd become frightened and I'd want to get out of there, they would and change it up and pretend like they needed my help to solve the crime. So that was the intersection, along with, could someone please mute yourself? There's like really background noise there. Please mute yourself. So eventually the police got me to agree to take a polygraph test, otherwise known as a lie detector, by telling me that some new information had come in through the FBI, had come in, it was in their files, and that they wanted to share that with me. But first I would have to take and pass a polygraph test. So the next day, rather than report to the high school, I instead went to the police station for the test. Because it was a school day, neither my mother or grandmother with whom I lived realized that anything was wrong. Therefore, they didn't call around looking for me. As far as they knew, I was in school. But the police drove me from Peekskill across county lines 40 minutes away to the town of Brewster, which was in Putnam County. There were 3 officers who came there with me from Peekskill, but then there was also the polygraphist who was a Putnam County Sheriff's investigator. He was dressed as a civilian. He never identified himself as a cop. He never read me my rights. I didn't have an attorney present. They didn't give me anything to eat the entire time I was there. They gave me the 4-page brochure, which explained how the polygraph worked, but then it had a lot of big words on it, which I didn't understand. But then I thought, well, I'm here to help the police, so what does it matter? Let's just get on with it. So from there, they put me in a small room and gave me countless cups of coffee in order to get me wired up. And then they literally wired me up to the polygraph machine. And that's when the polygraphist launched into his third-degree tactics. So he invaded my personal space. He raised his voice at me. He kept asking me the same questions over and over again. As each hour passed, my fear increased in proportion to the time. It was particularly frightening for me because I wasn't used to talking with adult males, much less ones who were conducting themselves in the manner in which this officers did that. So they kept that up for 6.5 to 7 hours. Towards the end of the interrogation, the polygraphist said to me, "What do you mean you didn't do it? You just told me through the polygraph test result that you did. We just want you to verbally confirm it." When he said that to me, it really shot my fear through the roof. At that point, the officer entered the room who had been pretending to be my friend, and he told me that the other officers were going to harm me, that he was holding them off, but could not do so any longer, that I had to help myself. When he added if I did as they wanted, that they would stop what they were doing, that I could go home afterwards, that I was not going to be arrested. Being young, naive, frightened, 16 years old, not thinking about the long term. Instead, just being concerned my own safety in the moment, I made up a story based upon the information which they had given me in the course of the interrogation and in the 6 weeks run up to it. By the time the interrogation was finished, I collapsed on the floor into a fetal position, crying uncontrollably. Needless to say, I was arrested. I was charged with the murder and rape. In terms of the prosecutorial misconduct and the fraud by the medical examiner, these two issues intertwine. When there's an autopsy done, there's written in audio notes which are taken contemporaneously as findings are made. So it was only after the DNA didn't match me, 6 months after doing that autopsy, hundreds of autopsies later, that this medical examiner claimed that he had forgotten to document medical evidence, which he said showed that the victim, a 15-year-old immigrant from Colombia who had been in the country for about a year and a half, leading a very sheltered life. She never went anywhere unless she was accompanied by her older sister or her parents, that she had been sexually active, which is what opened the door for the prosecutor to argue that it didn't matter that the DNA didn't match me. That didn't mean that I was innocent. It simply meant that there was yet another person she had slept with prior to my murdering and raping her. Taking it a step further, he actually named another youth by name that he claimed had slept with the victim. Yet he never set the proper evidentiary foundation for that. He never had a DNA test performed. He never even had that other youth called as a witness to give verbal testimony to that effect. He simply made the unsupported argument to the jury. At the same time, the public defender that I had essentially didn't defend me. Here are the ways in which he failed me. He never explained to the jury the significance of the DNA not matching me. He never used that to argue that it proved that that proved that the so-called confession was coerced and false. He never cross-examined the medical examiner to discredit him. He should have never represented me in the first place because of a conflict of interest. This other youth that the prosecutor was falsely claiming had slept with the victim was represented by another member of Westchester County Legal Aid, and specifically by the lawyer who was supposed to be supervising him on my case. That conflict prevented the defense from asking him for a DNA sample. It prevented the defense from calling him as a witness to explode the consensual sex theory. My interrogation had not been videotaped. It was not audio taped. There was no signed confession. There was simply the officer's word for it. And so as a result of that, when they came to court, they were able to leave the threat and the false promise out of their story. So I wanted to testify to put those facts on the record. But my lawyer wouldn't allow me to testify at the pre-trial hearing, which the court has to hold prior to statements being allowed into evidence. The prosecution has to prove that all the statements were voluntary and that the suspect had been given their rights. My lawyer wouldn't allow me to testify there. He said that he hadn't decided if I was going to testify at the trial or not. And in the event that I did testify at the trial, that if there was any variation, however slight, between my testimony at the pre-trial hearing and at the trial, that the prosecutor could make it appear as though I was lying, even if I was not. But then when we got to the trial, he wouldn't allow me to testify there either. He told me it wasn't his job to prove that I was innocent. It was up to the prosecution to prove that I was guilty, and he didn't think that it happened. But while that might be a legal principle, that's a very naive way to practice law. In reality, if your client is charged with a crime that he or she didn't commit, you have to try to prove that they didn't commit it, or else they run a risk of possibly being wrongfully convicted, particularly in a confession case where there's an 80% conviction rate where there's a confession. You have to answer that confession. You have to explain that confession. You have to disprove that confession in as many ways as possible, and then bringing it all together in your closing argument. Because the general public, which is what the jury is made up of, don't believe that an innocent person would confess. But he didn't do any of that. He rarely met with me. When I tried to explain to him that when I was innocent, what happened in the interrogation room, he was always shutting me up. One time he told me he didn't care if I was guilty or innocent. So added all of that up together, I guess it's not too surprising that the jury found me guilty. I'll never forget the day that I was found guilty. It felt like I was in some sort of nightmarish alternative reality, because to my way of thinking, at least up until that point in time, only the guilty were convicted. Yet they said what they did, and I was taken into custody. On the day of the sentencing, I begged the judge to overturn the verdict because I was innocent, and I referenced the DNA to support my contention. He actually told me on the record, maybe you are innocent. That didn't lead him, though, to exercise his discretion and overturn the conviction, which he could have done by reversing any number of rulings he made against me in the course of the trial. Instead, he took the easy, expedient way out, which was to sentence me to a 15 to life term of imprisonment, which I was sent to a men's maximum security prison in order to serve. I'd like to explain how I became exonerated. So I appealed my case to the appellate division, arguing my innocence based on the DNA not matching me. That was made in the form of an argument that there hadn't been legally sufficient evidence, that the prosecution hadn't proven guilt beyond a reasonable doubt, and that the verdict was against the weight of the evidence. The statements being admitted was another issue. My attorney argued that they were not voluntary and therefore they were admitted as evidence against me in violation of my Fifth Amendment rights. And then there were in total, there were 10 issues of law, which I'm not going to get into because that's beyond the scope of what we're doing tonight in terms of law and psychology. All you need to, an important thing to know is that the court wrote that there was overwhelming evidence of guilt. They found that the statements were voluntary and they ruled against me 5-0. And from there, it was all downhill. The re-argument motion was denied in one word, denied. The New York Court of Appeals declined to give me permission to appeal to them. I lost in federal court because my lawyer was given the wrong information pertaining to the filing procedure. So I lost on that. And that ruling was upheld by the next 3 courts. And so then my appeals were over. I went to the parole board, and because I maintained my innocence there rather than admitted guilt and taking responsibility, with their also citing nature of the crime, I was denied parole as well. And I ended up doing an additional year. Altogether, I did 16 years. The Innocence Project agreed to represent me. First, my case came to the attention of Claudia Whitman, an investigator. I got in contact with her by accident. I was writing a book authoring care of the publishing company, but the publishing company forwarded the letter to Claudia instead. When she saw that the DNA didn't match me, she was instantly convinced of my innocence. So she suggested that I write the Innocence Project again. As Dr. Takooshian referenced, they had previously declined to take my case back in 1992-93. So did all the other innocence entities. The case type that the Innocence Project was accepting at that time was cases where DNA could demonstrate innocence and in which no prior testing had been conducted. That wasn't an option in my case because the DNA had already been tested. So in a way, you might look at it that I was excluded a little too quickly for my own good. So fast forwarding to year 16, Ms. Whitman advised me just write them again. I wouldn't have thought to write them again. She lobbied them from outside the organization. She got other respected legal entities to lobby them. I got lucky that Maggie Taylor, who was a intake worker, who was not a lawyer at the Innocence Project, she represented my case several times to the Innocence Project because once again, they didn't want to go forward based upon the DNA already having been tested. She finally got it across with the argument that putting the DNA into the DNA data bank could possibly lead to a match to the actual perpetrator, and that would be something new. So they agreed to take my case. The DA, who had been fighting all of my appeals, previously left office, so her successor allowed me to have the testing. And lastly, we got lucky that the actual perpetrator's DNA was in the data bank. It was there because left free while I was doing time for his crime. He killed a second victim just 3.5 years later after killing the victim in my case. It was a school teacher and who was a school teacher and mother of 2. So on September 22nd, 2006, my conviction was overturned. I reported back to court November 2nd, 2006, at which point all charges against me were dismissed on actual innocence grounds. Changing gears, I became an advocate when I was released following a 2.5-hour off-the-cuff presentation to the media. Everything I'd ever wanted to say but could never get anyone to hear just came to my mind. And before I knew it, all that time passed by. And I realized at that point that I could be an advocate without necessarily being a lawyer. So I entered the speaking circuit. I became a columnist for a weekly newspaper. I was doing regular media interviews, trading privacy for awareness, and I was meeting regularly with elected officials, asking them to change laws in order to prevent what happened to me from happening to other people. So I did that as an individual advocate for 5 years, getting a scholarship along the way from Mercy College, which I used to finish the bachelor's degree. I then obtained the master's degree from John Jay College of Criminal Justice, where my thesis was on wrongful conviction causes and reform, which, as Dr. Takooshian referenced earlier, did involve an aspect of that pertained to prosecutorial misconduct. So after about 5 years, I was financially compensated, and I decided I wanted to go to the next level with my advocacy work. So I used some of the money to start the Jeffrey Deskovic Foundation for Justice, whose purpose is to free wrongfully convicted people and work for wrongful conviction prevention. So to date, we've been able to free 10 people who are wrongfully imprisoned. We've been able to help pass 3 laws in New York: videotaping interrogation, better identification procedures, DNA database expansion. Then, as part of a coalition group called It Can Happen to You, which I'm an advisory board member of, in which the foundation is part of that coalition, we're able to pass an additional 3 laws in New York pertaining to oversight of prosecutors, a tweak of that law, and discovery reform, which pertains to sharing information between the prosecution and defense. So now it's done very early in the process automatically, whereas previously there was a lot of motion practice back and forth. So, and there was a lot of legal motions asking for evidence. Often the prosecution would not turn evidence over until the eve of a hearing or a trial, and that was not enough time for the defense to really go through everything and, possibly conduct investigation. It could alter their whole theory of the case. So previously, the only way the prosecution had to turn evidence over would be if a witness was going to testify at a hearing or a trial, or unless the evidence pertained to innocence or mitigation and punishment. But other than that, nothing else had to be turned over. Now it's all automatically turned over very early in the process. And so anything beyond 30 days, the prosecution has to ask for permission from the court. So the foundation has as its mission the 3 R's: reversal, reversal, reform, recovery. The recovery aspect pertains to helping the exonerees reintegrate a little bit into society. At some point, it became not enough for me to sit in the front row of the courtroom. I wanted to be able to represent some of the clients. I wanted to be able to sit at the defense table, hence my foray into law school, becoming a lawyer earlier this year in pursuit of my dream of exonerating others as an attorney. So changing gears, in terms of wrongful conviction frequency, per the National Registry of Exonerations a few minutes ago, prior to this event commencing, the number from 1989 forward of exonerations in New York, in the United States are 2,754. That's not counting 3 people who were supposed to be released earlier today in court in Queens. It's important to note that those are just the people who made it out. It doesn't represent the total number of wrongful convictions. That's not knowable. That's not countable. In terms of wrongful conviction causes, one of the causes is false confessions. So I wanted to get into that just a little bit. So there's 2 types of false confessions. There's the internalized false confession, which is when the person confessing momentarily doubts their innocence. And then there's the coerced compliant false confession, in which the person who gives the false confession is aware that they're innocent, but they've been forced to comply. In terms of red flags there are certain patterns. So if the facts of a confession are in opposition or if the external evidence is different than the statements in the confession, that's definitely a red flag. A lengthy interrogation, particularly when combined with food deprivation, misuse and abuse of the polygraph, those are all signs that a confession may be false. If it's a co-defendant situation, if the co-defendants give a different story, that's also a red flag. Confessions that include sophisticated language, which is above the life experience and formal education of the defendant, that's also a red flag. The police stopping somebody and correcting them and giving them information, that's also a red flag. In terms of other wrongful conviction causes, misidentification is the cause of wrongful convictions in 75% of the DNA proven wrongful convictions. Reforms in this area to prevent that would include just viewing people one person at a time, making sure everybody resembles the description given by a witness and no one sticks out, letting witness know that the actual perpetrator might not be in the lineup so that there isn't undue confidence, letting them know that the investigation will continue even if no one is identified. A confidence statement, like how confident is someone in their identification. That's also part of the process, videotaping the process. And lastly, there should be no congratulatory statement afterwards because that artificially bolsters the level of confidence that a witness would have in their identification. In terms of wrongful conviction prevention of false confessions, which I forgot a minute ago, that would include videotaping the interrogation completely from beginning to end with the camera on both the law enforcement and the suspect, having a pretrial hearing where the accuracy or truthfulness of a confession is what is looked at instead of simply voluntariness, and then also allowing false confession expert testimony into the courtroom. They don't give an opinion whether a particular confession is false or not. That's a question for the jury. Instead, they just share contextual information on what are the factors that have proven to cause innocent people to falsely confess. Other causes of wrongful conviction would include prosecutorial misconduct that runs through many of the wrongful conviction cases. Common forms of prosecutorial misconduct would include improper statements in the closing argument or opening statement, withholding evidence of innocence, which is called a Brady violation, not correcting perjured testimony, which if a witness says something that's not true, the prosecutor knows it's not true, they have an obligation to correct that. Sometimes they do not correct that. Sometimes worse yet, a witness may lie about receiving benefits for their testimony, and the prosecutor swears to that in an affidavit. So those are some common forms of prosecutorial misconduct. In terms of preventing wrongful convictions caused by that, the Commission on Prosecutor Conduct, which is an independent oversight board for prosecutors, which would have subpoena power, the expertise to review prosecutorial misconduct, and the ability just to receive complaints anonymously or even investigate misconduct on their own initiative. We're very close to repassing that in New York. We've passed it in the Assembly. We're on the verge of passing it in the Senate. So that's about to go into effect. Again, we did pass it back in 2018. The New York State District Attorneys Association filed a lawsuit challenging the constitutionality of the commission before the judge rejected all their arguments, but did find a problem in the appeal procedure. So the statute was declared unconstitutional for that because it was the judge's position that it was up to the legislature to fix that defect, not for the court to do that. So we are about to repass that again, taking the judge's decision into account. Removing prosecutorial immunity. So there's a doctrine that says that if any misconduct the prosecutor does, once it happens after an arrest, that you cannot sue them for that, even for withholding evidence of innocence. Criminalizing clear-cut intentional prosecutorial misconduct. I think when the prosecutor, again, not questions of judgment, not gray areas, but outright indefensible misconduct, when that happens, I think it should be criminalized. In a way, it's kind of obstructing justice it is committing misconduct under color of law. I think having an automatic reversal rule. So right now, if a defendant challenges his or her conviction and argues that prosecutorial misconduct affected the fairness and therefore the validity of the conviction, reliability of the conviction, it's not enough that the court agrees with them, but they would instead then look at, well, whether it was harmless, whether you've been convicted anyway. And, to me, once a misconduct happens, it changes the whole lens by which the whole case looks. I think it's impossible to look in hindsight whether or not someone would have been convicted or not. And in terms of harmlessness, well, if it was harmless, then obviously the prosecutor wouldn't have bothered to engage in it. Mm-hmm. Bad lawyering is a major cause of wrongful conviction. I think that there should be one statewide system so there could be oversight and quality control. We need to limit the caseload. It's not unusual for one public defender to represent 100 people at the same time. There should be an even playing field in terms of manpower and financial resources between the public defender's office and the district attorney's office. There's a big disparity now. There should be equal pay for both sides. Incentivized testimony, or otherwise called snitch testimony, that's been the cause of wrongful convictions in 15% of the DNA-proven wrongful convictions. But I do believe in a external evidence corroboration requirement, meaning no one should be able to be convicted based only by an informant. So changing gears, I do want to briefly speak a little bit about the psychological after effects of wrongful conviction. It's common when somebody has been wrongfully convicted that they would have post-traumatic stress disorder and related symptoms, panic attacks and anxiety. It's not a feeling of having been frozen in time, a feeling of processing things at a slower speed, altered personality, fear on seeing law enforcement. The people who study impact of wrongful conviction on people say the thing that's closest to that would be somebody coming back from the war. There is a stigma with having been wrongfully imprisoned. So people don't question my innocence, for example, because the actual perpetrator was caught. But there have been people who, have embarked on a line of reasoning to the effect that you were in prison wrongfully for 16 years. Yes, but you were there for 16 years. But how much of that rubbed off on you? Is it safe to be alone someplace with you? I was released with nothing, so I did lack stability of housing. I bounced around from place to place. I nearly ended up in a homeless shelter. Thank God Mercy College gave me the scholarship, which included, which they modified to include the housing. I believe that people that are exonerated should be provided automatically with housing, cost of living expenses, doctor and dental care, mental health services, access to public transportation, job training, job placement, classes on technology, rather than just releasing them with nothing. New York State does give compensation, but it takes between 2 to 5 years to receive it. It took me 5 years to get any compensation. So it was a very difficult, experience. Last topic I'll briefly cover is wrongful conviction day. In fact, I'm going to save that when I introduce the second, our third guest. I'll get into wrongful conviction day there. I do consider myself as an advocate. I'm an attorney. My motivation is that I was exonerated, but I'm much more than just an exoneree. I have my life purpose, which is to fight wrongful conviction, freeing people who this has happened to, like it happened to me, and also working for wrongful conviction prevention, hence the policy changes. I am going to put, I will put my foundation's website URL in the chat. I will also put a link to our Patreon campaign. So, and right now we're working on 10 active cases. We're working on campaigns in 3 different states, wrongful conviction prevention measures. We have 7 cases that are approved, but just waiting in a queue. We don't have the bandwidth to be able to move those forward. So I am in the process of trying to raise funds. One of the ways I do have in my mind, I have the crazy idea that people might be willing to help free wrongfully convicted people. They might be willing to sacrifice $3 to $5, just a cup of cost of a cup of coffee, or eating out once, just one time a month. So we have a Patreon campaign, which is for people willing to be recurring monthly donors. My insane idea is, what if 25,000 people or more were willing to give up $3 to $5 on a recurring monthly basis? That would give us close to $1 million, and we would be able to hire additional attorneys, paralegals, investigators, other essential personnel to increase our capacity to get more people out, and we could work on campaigns to prevent wrongful conviction in more than just New York, Pennsylvania, and California. So with that in mind, I have done some international work in Armenia and also the country of Argentina. And so that brings me to one of our first discussants, Fabian Commando, who's an attorney. He's involved a lot in wrongful conviction prevention in Argentina. He has the only 3 books in print on wrongful conviction in Spanish. Those books are, I'll put the names of those, actually I'll mention the names of them to you right now. Memoria del Testigo Víctimas del delitos, condones erróneos. So Fabian is my colleague, and we're also friends. And with that, I'm going to turn it over to Fabian. He's going to give us an international perspective on wrongful conviction in Argentina. Fabian. Fabian.
Hi, can you hear me?
Yes.
Yes.
Yes, I can.
Yes.
Please continue.
Yes. Good evening, everyone. My name is Fabian Commando. I am from Argentina. I am a lawyer. I am a trial attorney who practices criminal law and also does some damages at civil courts. As Jeffrey told you all, I wrote some books. Two of them are specifically pointed to the topic of wrongful convictions. One of them is named La Memoria del Testigo, in English, Eyewitness Memory, in which I analyze what memory is, which are the main flaws that an eyewitness memory can have, and what can be done to prevent wrongful convictions on this basis. As you may know, almost 77% of all wrongful convictions are caused by eyewitness memory, and that's what I pointed at mostly. My work was mostly pointed to that point of view. In the book, I rely on authorities in the field like Dr. Elizabeth Loftus and Dr. Daniel Schachter, who you may know because they are worldwide scientists on that field. The second book is named Condenas Erróneas. That means in English, wrongful convictions. And as Jeffrey told you before, I analyzed this phenomenon and also which are the main causes. Again, pointed explicitly to the main cause of wrongful conviction, that is eyewitness testimony. I also consider myself an activist to prevent wrongful convictions, and with the help of my friend Jeff Deskovic, we could do some work here in Argentina, because in the presentation of one of my books, he came here and we did some work in front of local authorities, making some suggestions like the ones he mentioned before, suggesting to improve how lineups should be made, the need to record lineups, the need to record eyewitness testimony in general, and many other items. I will also like to tell you that I get involved in this activity to be an activist to prevent wrongful convictions because I knew at 2008 the story of Jeffrey. One night I was online reading at the New York Times newspaper. You are from New York. I'm sure you know that very iconic newspaper. And I was shocked that a person in the USA that I used to consider, and I still think has a very good criminal justice system compared to us in Argentina. And I read about the story of Jeffrey and how he was wrongfully convicted. That shook me up and made me think about this phenomenon that also happens here, because I am sure that some of my clients have been wrongfully convicted. Also, I was moved because I realized that judges here in Argentina and jurors too didn't understand completely how human memory works. And that made me investigate.
Fabian?
Sorry? Can you hear
I'm
me?
having trouble hearing you.
Yes.
Okay. Well, the other...
Difficulty with... Okay, continue. Fabian, we didn't hear what you said. Please repeat the points that you made about 2 minutes ago.
Okay. Dr. Takooshian, where did I stop? I was talking about the interest that the case of Jeffrey made me think about how human memory works. Did you hear that part?
Yes.
Yeah.
Well, also don't forget that Dr. Takooshian is an expert on memory, and I read about his work on the bystander effect, and I think that it is completely applicable today, Dr. Takooshian. Well, the other reason for making me be interested in this topic was the memory and human memory and the flaws of memory. And that introduced me to speak to the topic we're going to discuss today, How common are wrongful convictions in USA and in other nations, and what can be done to prevent this? From my personal point of view, I think that wrongful conviction is a phenomenon worldwide. And I'm sure that in Argentina, this happens too. For example, the problem here in Argentina is that in many cases, judges put a defendant in jail before he's being tried. So sometimes, for example, we had the chance to release somebody who's been found not guilty at trial, but he has been behind bars for more than 1 or 2 years. And that is the main problem here in Argentina. I mean, at least in USA, it is very easy for defendants to be outside jail while they wait to the trial. Here, when the crime that somebody has been indicted to is important, people go to jail and stay there until they are in front of the judge, And that is the problem. Innocent people who may be found not guilty at trial spend 1, 2, or more than 2 years behind bars. And what can be done to prevent wrongful convictions? From my point of view, I agree with what Jeffrey said in all the issues he mentioned, but I will point and stress the importance to improve how eyewitness testimony should be received, preserved, and validated or considered by the jurors or by judges. And in that purpose, I think that it is quite important the precedent from the New Jersey Supreme Court at the Henderson case. Did you hear about that? Well, the Henderson case is a precedent delivered in 2011 in which the New Jersey Supreme Court said, with the Chief Justice opinion of Stuart Ratner, that the jurors and judges should improve the way they analyze eyewitness testimony in order to prevent wrongful convictions. In this precedent, what the judges said is that people should consider the factors that could affect eyewitness testimony. And those factors can be grouped in two different factors. The factors that are under the control of the criminal justice system, those are the system variables, like how, for example, how the lineup are constructed, or the need to have blind administrators. That means that the person who takes the lineup does not know who the suspect is, so he cannot give any kind of information to the witnesses to pick somebody or not. And the other group of factors are considered the estimator variables. Those are the factors that are beyond the control of the criminal justice system. Like, for example, the importance of stress and how stress can affect the perception of the eyewitness. For example, the phenomenon of the weapon focus. That means that when a weapon is present on the crime, usually the eyewitness focuses his attention on the weapon and doesn't pay attention to the face of the person, for example. And that diminishes too the reliability of this eyewitness. So, from my point of view, this judgment is quite important because this Supreme Court pointed to these factors that, as I told you before, are the main cause of wrongful convictions. To conclude this presentation, I would also tell you that it is important to what you are doing. I mean, the youngsters and the students who with his presence and his interest in these kind of things, point the finger to this topic that is quite important, because wrongful conviction happens and can be prevented. In my country, I would say that from my experience as a trial attorney, judges are very prone to understand these factors. And when, for example, I had to make a closing argument mentioning these factors, and when the main evidence was an eyewitness, I had the luck to find that these judges found my defendants not guilty. To end, I thank you all. I thank the audience. I thank Jeffrey for inviting me, and especially Dr. Takooshian for this opportunity to have a talk. That's all.
Okay.
I'm open to any question.
Thank you. That will be at the end. Thank you very much. So
Thanks.
Wrongful Conviction Day is a movement started by Innocence Canada, in which all organizations and individuals across the world every October 2nd will do an awareness raising event on some level, whether it's a formal event, something informal, something to do with wrongful conviction, as a way of further raising awareness about wrongful conviction, with the ultimate goal that we could one day have Wrongful Conviction Day being on the calendar, which of course would be the ultimate way of raising awareness about wrongful conviction. And so that leads me to our next speaker, Ron Dalton, who was exonerated after 8.5 years for the murder of his wife. It was a crime that never happened. It was later determined that she actually choked to death. Ron is currently the co-president of Innocence Canada. He's previously served as a volunteer there, as well as a board member. He was exonerated after 8.5 years. Ron, in addition to discussing his own case, he will share with us the number of exonerations in Canada, and he will also discuss the systemic deficiencies that lead to wrongful conviction in Canada. And so with that, Ron Dalton, please unmute yourself and share.
Thank
Ron,
you. Everyone can hear me?
you have the floor.
Yes.
We can hear you.
Okay, thank you. I'm not going to spend a lot of time detailing my own case. Back in 1988, before a lot of these students were born, I was a 32-year-old bank manager living in a small rural town in a small province in Canada. You have 50 states in the US. We have 10 provinces and 3 territories. The particular province I was living in had 500,000 people in total. The town I was living in had 10 or 12,000 people. Small rural situation. I was a bank manager, married with 3 young children. We had a 9-year-old son, a 6-year-old daughter, and an 18-month-old son. And my wife choked to death on food at home. We called the ambulance right away. She was breathing when they got there. They took her to the hospital. She arrived at the hospital shortly before midnight, where the emergency room was being run by a student doctor who had never intubated, that is, put a breathing tube in a live patient before. As a student, this doctor had practiced on cadavers and was faced with the option of attempting to put a breathing tube in this live patient or waiting to call in the anesthesiologist and possibly losing the patient. The doctor opted to try the intubation. Unfortunately, he inserted a breathing tube into her trachea rather than into her esophagus, rather than her trachea, essentially putting a breathing tube into her stomach rather than to her lungs. And that kind of sealed her fate, because that tube gets sealed in place so no air can get around it. They worked on my wife for an hour and 15 minutes in the emergency room. The registered nurses, who had a lot more experience than this poor young medical student, stopped him a couple times to tell him that the lady was being blown up like a balloon, and they thought perhaps the tube was in the wrong place. He got his stethoscope out and said he could hear air passing. And
Excuse me for a minute. Please mute yourself. Please mute yourself. We can hear piano playing in the background. It's not respectful to our speakers. Please mute yourself. Please continue.
carry on. The upshot of all that is my wife died of a combination of inhaling some food at home and the medical misadventure at the hospital. Now, this particular town that we were living in had no pathologist, never mind a forensic pathologist. The province had a pathologist to respond to cases of those 500,000 people. This was somebody who was a laboratory pathologist used to doing tissue samples and blood samples, had no forensic training, and attended my wife's autopsy, thought because of some of the marks inside her throat that from this tube going in the wrong place, thought he had a homicide on his hands, told the police they better go visit the husband. They immediately took me in custody and charged me with murder. Now, the background is that I was living in a province where, particularly back in the 1980s, years would go by without a homicide, which if you're living there raising a young family as we were is a good thing. If you're trying to develop some expertise in forensic pathology, it's not such a good thing because you don't have the cases to build a body of experience so you know what you're doing basically. So a year and a half, almost 15, 16 months after my wife died, I went to trial and I had a private lawyer. I had gathered up whatever funds I could raise and my family could raise. And back in the 80s, it cost me over $100,000 of my own money and my family's money to get to prison. We hired a board certified forensic pathologist from Philadelphia to come and testify on my behalf to say that the poor hospital fellow didn't really know his arse from his elbow or know what he was talking about, basically. But at the end of the trial, the Crown prosecutor was able to turn to the jury and say, now, who are you going to believe? Are you going to believe the local guy who did the autopsy? Or are you going to believe this hired gun from Philadelphia who looked at a few pictures? And given that choice and expressed in those sort of terms, they opted to go with the local guy who had done the autopsy, found me guilty of murder, which in our country carries an automatic life sentence. The only thing the judge had to decide was a minimum number of years for me to serve, someplace between 10 and 25 for parole eligibility. Without conducting a hearing or anything, he sentenced me to life 10, so they would have had to serve a minimum of 10 years before I could even apply for parole. And in the particular province I was living in, the same one I'm in at the moment, there are no federal penitentiaries. We just didn't have the volume to warrant it, so I was taken to another province 1,500 miles away and incarcerated there in a maximum security prison. And to try and do an appeal from that distance, my money had run out by then, of course, so I had to go to what we call legal aid, like a public defender, and ask them to fund my appeal work. It took 2 years just to prepare the transcripts of my first trial, which was 6 weeks, because it was done in those days by court reporters in their spare time would type up transcripts. So we needed all those to go to the appeal stage. We lost a couple of years just waiting for that. The lawyers I was able to get to work on my case kind of got bogged down with it a little bit. They tried, and one guy worked on it for 3 years before he sent me a 2-line letter saying that it was becoming increasingly difficult to find the time to work on my case. Maybe I should look for somebody else, which took me another year and a half or so. So the upshot of it all was I spent 8.5 years before my appeal was heard. Now, the good news is my appeal was successful. My conviction was overturned, but a new trial was ordered. At that point, I was granted bail. This would bring us up to, I'd been out on bail for a year and a half or so before the first trial. This brings us up to 1998. It took 2 more years for the second trial to take place. I was much better represented at the second trial than I had been at the first or during the appellate process. We had a 6-week trial the first time. We had a 9-month trial the second time. Bit of overkill, but we went all around the world. We brought in all the world-renowned experts in forensic pathology, emergency procedures and resuscitation, this sort of thing. So I was eventually acquitted in the year 2000.
Excuse me, please mute yourself. Someone is not muted. Please mute yourself.
Tito, perhaps?
Ya está el trabajo listo.
From my arrest.
Sí.
Y si dejo que pase, va a ser igual que el otro, va a tener que estar rogándole.
Excuse me, somebody please mute yourself.
I think we got it now. From my original arrest in 1988 to my eventual acquittal in 2000 was 12 years. And I always epitomize those 12 years by our 6-year-old daughter who had just graduated kindergarten the year her mother died. And my jury in the year 2000 came back on the 20th of June on a Saturday and acquitted me. I spent a day and a half driving to where my daughter was living with my family in another province, and I made her high school graduation that Monday evening by about 2 hours. And the 12 years in between her kindergarten and her high school graduation were all missing to me. So that was my sad story. It's one of many, and it's far from the worst of the cases that we've looked at in Canada. So just a little bit of background about Innocence Canada, if we have the time. We're a non-profit organization. We represent people across the whole country. We're the only national organization in Canada. Canada is geographically larger than the US, so we have a lot of territory to cover. We have a much smaller population. We have 38 million, and you guys are 330 million or some such thing. But we have a lot of area to try and cover. And being a nonprofit organization, we spend half of our time raising money to exist, and the other half trying to do the work that we're dedicated to doing. We started in 1993, back when I was still in prison. And in the last 27 years, we've had 27 exonerations, and we have 10 more cases now pending in front of the federal justice minister in Canada. The process in Canada is if you've been convicted, and we only have the resources to look at homicide cases. We don't look at all of the other wrongful convictions that might be out there. In Canada, if you're convicted of a homicide, you go through the appeal process. If you lose your appeal, you can apply for leave to the Supreme Court of Canada, which only in rare cases will even look at homicide cases. So at that point, when your appeals have been all exhausted, you can then apply to Innocence Canada, go on our waiting list, which is sometimes 7, 8, 9 years before we can get to your case. Give us 5 or 6 years to review your case. And if we are convinced that you are innocent and that we can demonstrate that, which generally involves some fresh evidence, we'll put together an application to the federal justice minister, which is one of the last faint hope clauses we have in our Constitution, where we are allowed to put together an application, and the federal justice minister can look at it. They can then take 5 to 6 years sometimes to review it. They start the process all over. They review, they investigate. They'll put together, their department will put together a recommendation for the minister, who has the power to overturn the conviction, but more often, if you're successful at all, will refer it back to the court from which it came. And then the Crown will have the option to retry it or decide they don't want to try to retry it. So it's a very long process. And we're very fortunate that we've been successful in, and I hate to even say it out loud, in every case that we have sent to the ministers so far for review, we've been successful. But our organization literally spends years and years investigating, reinvestigating, putting together the application to make sure it's pretty gold-plated by the time we present it to the federal justice minister as a case of wrongful conviction. Now, what we've been arguing for the last 25 years, not only ourselves, but some of the public inquiries that have been held into cases, my own included, after wrongful convictions, there's recommendations been made that our country adopt a publicly funded independent body to do the type of work that we're doing, as they have in the UK, New Zealand, Scotland, some other countries around the world actually have an independent body that doesn't report to a politician, it reports to the legislature, and it has the powers to do some of the work, but it also has resources that a nonprofit like Innocence Canada doesn't have. And Jeffrey mentioned, in the work that he does, he's trying to raise money for cases all the time. And that's the nature of what we have to do. It's one of the big problems that we have. Trying to think of what else. In terms of causes of wrongful convictions, I think as Fabian pointed out, that's something we all have in common. The poor eyewitness testimony, the junk science or poor forensic science, the tunnel vision or confirmation bias we refer to as it sometimes, the Crown culture sometimes, the prosecutorial culture that they have to win at any cost rather than seek justice. It is an adversarial system in most countries, our own included. Now we have a bit of an advantage in Canada. We have a much lower population. Our crime rate is lower, but we still have a significant crime rate, particularly in our larger cities. But we also, since 1976, do not have a death penalty. So even though it takes a lot of years sometimes, we still have the opportunity to correct some of these mistakes. One of the cases that we resolved was 49 years old by the time we resolved it. And it had involved a 14-year-old boy who had been sentenced to hang. But his sentence got commuted to life, and he served 10 or 12 years and led a life, raised a family, and then decided he wanted to clear his name. We were able to resolve that 49 years later. But not having a death penalty, I think, is significant, because when we look around the world, there's still lots of jurisdictions, including many states in the US and other places, where with the death penalty, and Jeff, I'm sure, like myself, at some of these Innocence Network conferences, you've met people who have come off of death row, and they can tell you how close they came to dying for somebody else's crime or for a crime that didn't happen at all. So those are scary things. In addition to the reserve powers that the minister has in this country, after wrongful convictions, and we've had a total of almost 70 that we know of in the history of the country, in many of those cases, particularly in the last 10 or 15 years, after the wrongful conviction is unraveled, the person is exonerated. Sometimes the actual perpetrator is convicted and sentenced. We've commissioned public inquiries, which are very expensive proceedings. They'll take 2 to 3 years. We'll generally appoint a retired judge. We appointed the retired Chief Justice of the Supreme Court of Canada to look into my case. And they'll go and they'll ask what went wrong in these cases. So we've learned a lot from interviewing the people involved, the police, the prosecutors, the judges, the victims, being the wrongly convicted people, to see where the mistakes were made. And invariably, it goes back to that same list that Fabian and Jeffrey have mentioned, the tunnel vision, the unreliable witnesses, the lack of disclosure, the inadequacies of counsel, junk science, discrimination we're finding increasingly in our country has been a factor. Indigenous people in our country have not always been treated fairly before the courts and the laws. And we have one that's a little unique to Canada. I don't know about Argentina. I know they don't use it in the US. We call them Mr. Big stings here. They're a form of entrapment where you find often a young, unsophisticated, marginal member of society who's a suspect, and the police spend millions of dollars and sometimes a year and a half befriending this person and pretending they'll give them money to take an envelope from one side of town to the other side, and eventually convincing them that they're working for the mob or some big gangsters, and Mr. Big wants to meet with you at some point in time, and they're put in a hotel room, sometimes plied with drugs and alcohol. Sometimes they're given companions to spend time with, and at some point there becomes a confrontation where Mr. Big in this fake crime organization wants you to confess what you've done. We heard about you killing that 15-year-old girl, in Jeffrey's case, and we want you to work with us, but we got to be able to trust you, so we can help you with all this, but you got to tell us what you did. And they'll get this person to deny it 99 times and record the 100th time when they say, yes, that's what happened. And then they'll call that a confession and use it in court. And our courts are starting to overturn some of those convictions, but they haven't overturned them all yet. The technique is still being used. So it's something that's not used very much. Australia still allows it. Most of the other Commonwealth countries do not. And I'm pretty sure that the US does not allow that form of entrapment. So our numbers are lower. Our incarceration rate in Canada is about a sixth of what it is in the US. We're higher than many countries in the world. We're much closer to Argentina's own incarceration rate. We might be a little bit lower, but we're not terribly proud of ours. We always look down at the US and say, oh, well, at least we're better than they are. You know, we don't have the death penalty, and we're not incarcerating people at 6 or 7 times the rate that that they are. But we have a lot, we share a lot of the same problems and the same types of issues trying to get this overturned. And politically, justice reform and prison reform, getting people out of prison, is not that politically popular. It's generally more popular to say, I'm tough on crime, you know, I want to build more prisons, not empty out the ones we have. And it's an educational effort as well. Like we spend most of our resources go to working on cases, but we do try and do some educational work, including seminars like we're having here this evening, just to let people know that the knee-jerk reaction of getting tough on crime or bring back the death penalty because there's been a horrific crime committed is not the answer. As Fabian said, to get people to understand that eyewitness testimony is quite often not at all reliable. Can be a challenge. So that's some of the type of things that we're doing here in Canada. In my own case now, after my own exoneration, I spent another 7 years in civil courts trying to get some compensation for myself and my family for what we went through. And that took 7 years on top of the 8.5 or the 12 years I had spent at that point. And 32 years ago, I was a 32-year-old bank manager and I had hair. And now you can see what's left, you know. This is now the upside of all that is I've been out of prison for over 20 years now. I've remarried, and those 3 little children that we had are now grown with children of their own, and I get to do some grandparenting things. And I was able to fight a settlement out of them that helped out the family a little bit. Didn't give us back any time that you've lost, which you can never get back, of course, but it made life a little bit easier. We managed to pick up the pieces and carry on as best we could, as we all have to do. And I must say, before I go, I just wanted to congratulate Jeffrey. I think probably the last time I met with him was maybe in Orlando at the Innocence Network conference there. At that time, he was trying to peddle some board games for wrongfully convicted family members. But since that, he's gone to law school and he continues to advance. So he's a bit of a shining light for the rest of us, you know. He makes us look like slackers. Anyway, I won't take up any more of your time than that, but any questions you have, we're certainly open to.
Well, thank you very much, Ron. And at this point, I think we'll open for Q&A. I'd like to get within one of the first 3 questions. I do want to recognize another fellow advocate and researcher in the audience tonight, Dr. Marina Sorochinsky, who's done a lot of work in wrongful conviction. So I am hoping to get a question or statement from her within the first 3 people. Let's get some student questions first, though. I guess Harold, I'll let you call on students and facilitate that, and we'll get Marina in there shortly.
Well, Bob is the moderator, but I see we have Andrew Carmen on our webinar. Maybe we can encourage him to comment. We described.
Yeah, one of my former professors, by the way. And
pardon?
Yeah, I just wanted to say, Professor Carmen is one of my old college professors who facilitated. Yeah, he facilitated my master's thesis, and at one time he did serve on the board of the Jeffrey Deskovic Foundation for Justice. So welcome, Professor Carmen. Would you like to give a comment or two?
Yes, thank you, Professor Takooshian, and thank you, Jeffrey Deskovic. I just want to tell you that whenever in our criminology classes we talk about wrongful convictions and miscarriages of justice, the students come alive. It's a subject that people feel very passionate about if they're concerned about social justice. Thank you.
Professor Sorochinsky, would you unmute yourself and just share a comment with us, please? Maybe say something from a research point of view.
Hi, everyone. Thank you. Thank you for putting me on the spot here. Was not planning
You
on.
can talk about this stuff cold. You can talk about this stuff cold. You're an excellent researcher.
But I really appreciate you doing this, and it's great to see this international panel. It's one of those, perks of doing events online, that you can easily bring people from all around the world together. It's the first time I'm actually seeing and hearing people from Argentina and Canada speak about those same issues. We need more of it. We need more awareness. We need more research. I'm currently doing one small project looking at what happens with wrongful convictions in serial crime, and how issues of linkage kind of intersperse with those issues that you have talked about in terms of confessions and eyewitnesses. But how does that happen when the true perpetrator continues doing other crimes, and the police kind of just either not aware or ignore that happening? So that's kind of another layer, really, of victims that few people really think about. When the wrong person goes to prison, the real perpetrator is out there, and more people get hurt. Like in Jeff's case, the perpetrator actually ended up killing and raping another girl. And it's the victim tree is really perpetual if you think about it. It's the families, as Ron was talking about, the families, everybody suffered, the friends, the families, the wrongful convicted person, and then all of the other potential victims of the real perpetrator. So the impact of this injustice is immense. It's not just the one person who gets wrongfully convicted who needs that justice rectified, right? It's a lot more people. And so thank you for doing this, and I'm really happy to see a lot of my students here as well from St. John's University. I'm going to talk about that same topic actually next week with my forensic psych class, so you guys get a heads up.
Okay, so at this point, I'd like
Jeffrey.
let's like to get maybe some students.
Well, Jeffrey,
Go ahead.
Bob Evans, I'm going to jump in for the second. So, how are you doing?
Please do.
Yes,
I'm good, thank you.
Yes, Jeffrey, I'm going to focus on obviously the topic right now, the subtopic of false confessions. When you talk about the police and how they interrogated you, what statement do you think that they made most influenced you to ultimately give you the confession?
I would say it was the combination of the threat. When the officer had been pretending to be my friend, he told me that the other officers were going to harm me, but that he was holding them off but could not do so any longer, that I had to help myself. So the threat, and then when he said that, just tell them what they want to hear. You can go home afterwards. You're not going to be arrested. So the combination, that 2 punches really what sent me over the edge, coming on the heels of the 6.5 to 7 hour interrogation.
Right. We submitted to the class an article from the New York Times about some false confessions. And it seems like the latter statement that you talked about where the police promise something they have no ability to actually carry out. And that is that you're just going to go home and you're not going to get arrested. That seems to be a huge factor in leading to false confessions. New York, obviously, as you may know, Jeffrey, and the other gentleman may know, allows the police to lie or at least use trickery to confessions. If we eliminate that and make that improper and illegal, how much do you think that would impact false confessions?
I think it would impact it a lot. There is, in fact, the country's leading false confession expert, Saul Kassan, wrote an op-ed in the New York Times recently, arguing that very point. And there is a bill in the New York State legislature which would prohibit the police from lying. So I think that would really go a long way, because it is in fact coercive. And you tell a suspect, you falsely tell a suspect that you have evidence that doesn't exist, that often conveys the utility of anything less than a confession.
Absolutely. And then when they're so frightened that you tell them they can go home and it's all over, when it's really not, people are going to say, people lie on a daily basis. I'm not saying in terms of about convictions, but it's something of this consequence. And then you tell them, I can leave, nothing's going to happen to them. Anyone wants to get out of that situation. It's human nature. And I think that kind of police conduct has to be stopped to prevent a high percentage of these false confessions. Fabian, a question for you. In Argentina, do they videotape confessions?
Well, Argentina is a federal country, so it depends on each state. Now they are beginning to record every kind of evidence, but up to a few years ago, no. But false confessions are not common in our country. Almost nobody confesses. And that is a good answer that our own constitution has given. Even when somebody confesses, it is not enough evidence to convict him. Did you know that?
You can't solely rely on the confession to
Yes,
find
you
guilt.
can't. You can't rely on confession by that.
You have to corroborate it with other evidence.
Yes, that's the need. Our constitution gives enough support to everybody to, at least in this evidence, no, to rely not only on confession. They need corroborating evidence. Yes, but even though that in our criminal justice system, almost anybody confesses. Just those who are found in front of the crime scene and they have no other way to escape justice. But in other cases, almost nobody confesses.
Now, why do you think that is if so few people confess?
I don't know, but it is not usual. That's why when I spoke, I put emphasis on the most important cause of wrongful conviction here, that is eyewitness evidence.
Ron, do you find in Canada that there is also is there a movement to film confessions by law enforcement?
Get myself unmuted here. Yes, there is actually. And like in Argentina, the situation has gotten much better in recent years. When I mentioned those coerced statements, those Mr. Big stings that they do on people where they try and entrap them into saying something. We had a case 4 years ago now that said you can no longer rely solely on that type of a confession. I hate to even call it a confession, but you need some corroborating evidence now to go with it. If you have a confession like that and some DNA, then that may add to your case. But if you only have a coerced confession like that, then it's not enough to hang a conviction on anymore. So the situation is getting better.
Do you find a change in the culture? You talked about I was a prosecutor for 30 years before I am now in a different field of law for the last 10. So I know that culture, and it really depends on the leader from the top. I luckily worked for a DA who was most concerned about getting things right as opposed to winning. But there clearly were people in our office that hated to lose, and winning was unfortunately the most important thing to them in a criminal case. And that culture, if it's coming from the top, I think prevents justice from being done as often as it should. Do you see a change in the culture in Canada as time goes on?
Yeah, I think we're trying to make some inroads, and Innocence Canada does work with some of the prosecutors here in our country. But it's an adversarial system, and human nature is that when you pit two professionals against each other in front of an audience, they each want to win. Right. Now, in our country, our prosecutors, including our deputy ministers and other top prosecutors are not elected officials. They're all on the government payroll. Whereas in your case, I think a lot of your district attorneys and stuff stand for election. As do some of your judges. None of our judges in the criminal courts are elected. So we consider that an advantage.
Jeff, a question. Other than DNA, which has been an incredibly valuable tool to help prove people are innocent, what are other tools that you see are invaluable in terms of preventing wrongful convictions or overturning wrongful convictions?
FOIL requests, Freedom of Information law. So often when FOIL requests have been filed, it leads to the turning over of documents that have previously been withheld. And sometimes those are enough to overturn a wrongful conviction, while at other times it furnishes a new investigative point. So there's that. Looking at police reports. So if the police interview somebody and they reference a third party, and it's clear that the police have not, spoken to that third party, so going to speak with them. Looking for alternative suspects, searching for similar crimes in nearby areas. Those are some of the ways that you would work to overturn a wrongful conviction case in a non-DNA case. I do want to just make a brief comment that I don't think that having prosecutors run for election, there's plenty of peril in that. In fact, I think that drives the win at all costs culture. When someone is running on a tough on crime plank and they say, "Oh, I'm keeping us all safe. Reelect me. I've got a 98% conviction rate, 99% conviction rate." I think that's a really big problem. I don't know. Of course, going with a district attorneys that are appointed, then they're going to be, the people that are going to be picked are going to have a similar political outlook to whoever the elected official is. So that's not really a satisfactory way either. That has plenty of downfalls as well.
Okay, gentlemen, I think I'm going to stop talking on my end for the moment. I'll probably jump back in, but let's turn it over to the class now, both here and the many people online, to see what questions they may have. Anyone in the classroom here first? Any questions for any of the panelists? Okay, we'll turn it online. Anyone who wants to put up in the chat a question that can be asked, or you can ask it directly, please let us know if you want to ask a question.
Yes, I would like to ask a question. First of all, can you hear me?
Yes.
Yes. First of all, I would like to say to Dr. Takooshian and all the rest of the speakers, this has been a wonderful symposium. It has been really wonderful. I would like to know, I have a lot of questions, but one of the things that the rate of exoneration rate, there has been many studies regarding by race, by age, by sex, by ethnicity. Do you see a trend in this regard, by the way? Mm-hmm. And also, by the way, in comparison between nations, nations who come from a democratic perspective versus authoritarian rules, such as military rules. Do you see a differences between those two? So those are some of the questions that I have for the panel.
So in terms of ethnicity, while wrongful conviction does cut across racial lines, and it does happen to people of all races, it does happen more frequently to minorities. If you were to count up the total people in the National Register of Exoneration, you would find more minorities than Caucasians. I do want to say that an African-American defendant is 7 times more likely to be wrongfully convicted of murder than someone who's Caucasian, and they're 3.5 times more likely to be wrongfully convicted of sexual assault. I don't have the answer. I'm not aware of any study with respect to comparing the racial dynamic, racial makeup of wrongful convictions in the U.S. versus other countries. I've never really thought about, forms of government, democratic authority or versus authoritarian versus militarism. I think that's kind of a new concept, even just in the question. So I can't speak to that part of it.
I'm just going to throw
Yes,
out.
let me just ask. Yeah, maybe I just ask Marina that. I mean, Marina is, does lots of studies, and of course that means she has to read a lot of scholarly papers. Have you ever heard of those particular angles on wrongful conviction? Have you come across that in any of the scholarly literature? Because I have.
The issue with the racial differences in wrongful convictions, I think that is a very highly U.S. centric issue because of a lot of other systemic racial issues in how it works, and also because, as you have all discussed, the eyewitness misidentification. Cross-racial identifications are a big issue, right? You know that probably. So if the victim is white and the perpetrator is African American or Black, there's a much higher chance of misidentification because of how we tend to recognize or not recognize differences in facial features. As far as the government, I think that is a very difficult question because in totalitarian countries, in countries where the regime is not a democracy or where there's no issue, there's no possibility of questioning the authority. I mean, even here in the US, look at how difficult it is to overturn a conviction. And imagine now if it's a totalitarian country where the authority of the governor or the government or the powerful people is literally not allowed to be questioned. So I'm sure there's a lot of it going on there. There's absolutely no way we can actually know how much, or even again, with how little and how difficult it is here to overturn convictions, there it's practically impossible. It's so, yeah, but there's no statistic on that for sure.
Yes, Marina, I would jump in and agree with you. But Jeffrey, do you know any country with an authoritarian government that actually has an innocent project?
No, I'm not aware of one. No.
Ron, I know you want to jump in on something.
I would just add to what Marina was saying. Leo makes a good point. We know in Canada that our Indigenous population, which is not terribly large, they make up 5 or 6% of our general population, are disproportionately incarcerated, and they are disproportionately clients of Innocence Canada. They have language barriers. We put these people on reserves, and particularly with historical cases, we're dealing with some cases that go back 40 and 45 years, and the attitudes were even worse then than they are now. We isolate some of these Indigenous people on reserves where they don't have the same level of education. They have healing circles rather than courts. They don't understand the system. We've had a number of clients who didn't speak the English language being interrogated without anybody representing or interpreting for them. We had 4 individuals picked up in their teens for a homicide, put in 4 different rooms, and signed almost verbatim identical 3-line confessions that were put in front of them, clearly not their own words. And 3 of those 4 didn't speak English. There was very short confessions written out, placed in front of them, and after a day and a half of being interrogated, they signed these things as teenage kids and thought they were going home again. So we know that the race certainly plays a role. So in both the convictions, incarcerations, and the wrongful convictions. And it hinders, these people are at a disadvantage when they're trying to access the limited means to unravel a wrongful conviction as well.
Right. It's basically an issue of minority versus majority, as opposed to any particular given race being particularly prone to it. So in the U.S., it's more African American and black people. In Canada, Indigenous, and in the Europe, it's Muslim and Middle Eastern people. So it's not particular race. It's more of an issue of a minority disadvantages that come kind of together as a package.
And just one final comment to add to that. It's not only issues of race, of course. It's marginalized people in society, the poor, the people with the least resources, the least education, the people that are easier to convict. They make easy targets. I'm an outlier. I had a white collar background, university education. I've met other people like that, but we're the exceptions that prove the rule.
I just want to say, Bob, maybe you could read the questions. There's 3 questions pending in the chat right now. If you want to read them, and we'll take stabs at them.
Sure. How would you pull those up?
Not sure what it is.
In the chat.
If you want, I'll read them. I don't want to.
Oh, no.
I don't want to be perceived as hogging the microphone.
Okay. One question.
Right, so one of the questions.
Please go ahead, Jeff.
All right. So one of the questions is whether or not there's a higher rate of wrongful conviction of males rather than females. Yeah, the short answer, I would say yes. The female incarceration rate, the number of prisoners is significantly less, and so just by virtue of that, it would be less. That having been said, like other wrongful convictions, you can only count the exonerations. You cannot count the wrongful convictions because those cases aren't known to us, and to the extent that the majority of the innocence organizations, and this is one of the ways the Descovich Foundation distinguishes itself, because we don't limit ourselves to DNA cases, but the majority of innocence organizations only take on DNA cases. That typically lends itself to murder and rape cases, and those are not the types of crimes that women are generally wrongfully convicted of. A lot of women have been wrongfully convicted in shaken baby syndrome cases, which is basically a default diagnosis. So if an infant dies and there's no way of determining medically how they did, then they just look at the last person that the infant was in the custody to, and that becomes a shaken baby case. So a lot of women who are engaged in babysitting either their own children or others often are wrongfully convicted of that. And for the most part, there's not enough people working to free wrongfully convicted people. So that was one of the questions. Another question pertained to post-traumatic stress disorder and what was effective with that, and how it's been able to have been overcome. So I did a combination. I did EMDR, so eye movement desensitization reduction. So that's and it was, at the time, was innovative therapy, but basically it removes the emotion that is associated with memories. So some of that helped, and I think that just the more time passed by while I was free, and the more I understood technology, the more tied into the world I became, and I think that was true on the cultural level. And being financially compensated also helped mentally some. Ron, do you want to speak anything as to overcoming PTSD?
For me personally, some of the best therapy I've had is the half a dozen opportunities I've had to walk wrongfully convicted people out of prison. These are cases that we've worked on for many years. In 2 of those cases, they were people that I actually served time with. And 21 years later, in one case, we were able to walk an individual out of prison that I had been helping them write letters, back in the prison days. So that was very, very uplifting. But some of the work that we do, when my case was over, I looked around and said, I know there's more people like me left behind. What can I do? And I stumbled across this organization that was doing this type of work. I volunteered a bit. They talked me into going on the board. I'm now one of the co-presidents, and I don't do it full time. I think that'd be too hard on my head, and we don't have the resources to pay me to do it. And I still keep my hand in a little bit of accounting and stuff to earn a living. But giving back and working on cases like this and getting a little not a little satisfaction, a lot of satisfaction out of helping free other people that were in the same situation, and some of them incarcerated much longer than I was. That's been very helpful for me. And when that doesn't work, there's always the grandchildren.
I want to just quickly add also that doing advocacy work I do find to be healing and cathartic. I did want to share with people that there is a documentary short about my advocacy work and life after exoneration, which is available on Amazon Prime. It's called Conviction, and the document, in reference to one of the other questions, the documentary has resulted in my getting additional exposure, and with it, more importantly, just the issue of wrongful conviction getting more exposure, and it's led to a lot of interviews. So if you want to see more about my life post exoneration, my advocacy work, go to Amazon Prime, look up Conviction, drop a comment if you're it would be helpful if you did that.
We haven't had a student question or comment yet. We hope somebody would do that. This is a seminar and it's supposed to be interactive. Just jump in. If you have a comment or question, just jump in. Let me ask two quick questions. One, Ron's case did not involve DNA, but most cases, instead, like Jeffrey's, did involve DNA. What percentage of the wrongful conviction overturning involves DNA?
I can take a stab at it from a Canadian perspective. We tend to refer to the DNA cases as the low-hanging fruit. We've had 27 exonerations in our organization. Less than half of them have involved DNA. In some respects, it's easier to unravel those cases if you do have some DNA evidence. You can not only clear the wrongly convicted person, quite often you can, same as in Jeffrey's case, you can identify and lead to the conviction of the perpetrator. That's very satisfying as well. It's not our primary focus, but it's nice when that happens. But we, like Jeff, don't stop at just the DNA cases. And the more time that goes on, the fewer and fewer of those easier low-hanging fruit cases are around. The ones that you have to spend 7 or 8 years doing investigative work and trying to unravel what happened sometimes 20 or 30 years ago. And of course, sometimes preservation of evidence is one of the issues that we run into. And we haven't mentioned it yet this evening as one of the issues that lead to wrongful convictions, but sometimes the evidence gets thrown out, it's not preserved properly, and you have to fight to get access to it. So that disclosure and access to evidence can be a problem.
So Innocence Project is not just
I want to.
Please.
Well, Ron was really speaking about Innocence Canada, not the Innocence Project. The Innocence Project is in, the group in New York, the first entity, which is why the other entities, put the word Innocence Project as part of their name, connoting that they're following the, practices of the Innocence Project in New York. They are DNA centric. DNA, by the way, is only available in 5 to 12% of all serious felony cases.
One other question, if I may. Jeffrey mentioned Orlando. You folks are part of an international movement. When you have conferences, what kind of tone is there in the conference? What is the feeling of a conference on exonerations?
It's a lot of camaraderie. It's really nice to see people across the country that are engaged in the same type of work that you're in, that know the type of hardship and struggle that's involved in doing, this type of work. The victories are possible, but there's a lot of stuff that goes into it. So it's nice to see people like that, and friendships happen there as well. So there's that. There's a little bit of learning also, and it's really life altering for me. The highlight always is the Friday night of the Innocence Network conference. So after the main speaker, there's always there's like a big jumbotron / television type thing, and all the people who have been exonerated between last year's conference and the current one, you see like a 3 to 5 second video clip of them being released at the finding moment, and then their name is called, and suddenly that person appears on the stage, and it references all the pedigree information, like how much time they did, what state, what the charge was, and so you wind up with like about 100 plus people on stage just from that alone, and then they call us old timers there who've been out for a while, so the stage fills up with exonerees that way. So it's a really it's like a renewing of it. It would be like having a best friend that you see maybe once or twice every year, but when you see them, your feelings of affinity and camaraderie are not lessened. Like you pick right back up as if there was no time. So that's my experience. Ron, if you want to add anything.
I would say that certainly the social aspect is very rewarding. You meet all kinds of people, but you also meet people like Brian Stevenson, very, very inspiring. You look at the work that he's done. Reuben Hurricane Carter was the executive director of our organization for a number of years. One of the main satisfactions for me, volunteering with and being on the board and co-president of Innocence Canada, is I have met personally half of the wrongfully convicted people in this country. And those are friendships that I value, but it's a networking thing when you get the opportunity to get together with people who have like-minded, but also the academics and the practitioners who work in the field. You make a lot of connections. You might bump into that DNA expert from California that you need in your next case in Vancouver, Canada, someplace,
So there's more questions.
Let me pretend to be a student and ask, is there any way students can be involved in your work, either as interns or some other capacity?
We take interns. It's very competitive. We get more people that apply than what we can accept. But interns is definitely, internships are possibilities, and so are people who just want to volunteer. I'll put my email address in the chat.
Coincidentally, I had an email from our office today. Our main office is in Toronto, and I'm quite a distance away from there. But we were going over the applications of 106 people who have applied for 2 summer intern positions in our office. And over the last 25 years, we've used a lot of volunteers, and not just students. We've had volunteer lawyers and just members of the general public who came from wanting to do some social justice work, doing volunteer work for us. We would never have gotten as far as we have without our volunteers. We have a small paid staff, but the volunteers have made up the backbone of this organization. Many of them students, but not exclusively students.
The question was very timely because we're actually at a point where we have 2 to 3 slots available now. Actually, our last bunch of interns have concluded their term, so we're actually in the market for interns. There was a statement in the chat commenting about a lot of wrongful conviction cases happening in Brooklyn. The short answer is yes. The more sophisticated answer is that there's more wrongful convictions being overturned in Brooklyn, not necessarily that there's more wrongful convictions in Brooklyn. There was another question about whether I ever look back. It says, do you ever look back? So I guess Ron could answer as well. Do you ever look back at what you've gone through most days to motivate yourself? for me, the answer is definitely yes. That's why I do the work. I'm trying to help people that this has happened to already. So I'm always thinking, as I always see myself in other people. Go ahead, Ron. You want to add a comment on that?
The more years that go on, the less and less I look back. I'm proud to say that in December this year, when the anniversary of my conviction rolled around, my sister called me, and this is the same sister that raised my 3 children for 10 years when I was not around. She called me and asked me if I remembered what day it was, and I hadn't. So I think that's a good sign.
Absolutely.
But I want to add also a different aspect that, in considering myself as an advocate and now as an attorney, I try to judge myself according to, if I was doing the same exact work without having been wrongfully convicted, and I try to hold myself to that standard rather than just giving myself the easy way out and saying, yeah, but you were wrongfully convicted and other people were not. So that was a different shade of that.
Jeffrey, just a quick question. What is the focus of your practice, your legal practice at this point?
Wrongful conviction. Specifically, we're mainly we're trying to exonerate people, but then I do want to help them get compensated on the back end. So, the foundation is the vehicle by which we do the exonerative work, and as a individual attorney, just collaborating, with other attorneys on the civil side, that's a different entity. But I'm only interested in using the law degree on wrongful conviction cases, either side, the criminal or civil, and also using the law degree to further the policy work that I do.
I guess I was asking in terms of pre-conviction. Are you working on cases where you think the person is innocent, but not yet has been convicted?
No.
Do you know people that
No, the short answer is
that?
Well, those are regular trial attorneys. I mean, the most I do on that, people contact me a lot through email, through social media. So I do a little bit of consulting or do a little bit of general advice, but I don't, that's not really my area of I don't have my specialty is the wrongful conviction cases is number one. Number two, there's only so many hours in a day. And number three, one of the ways we're able to make an educated guess as to whether someone's innocent or not is because there's already a developed record. And in the case of somebody pre-trial or even pre-hearing, the same record doesn't exist. So it's a lot harder to make that assessment.
Thank you.
I think it's time to thank our speakers. We just wanted you to know, Jeffrey, that we expect to see you in person and put this medal around your neck because you really deserve a medal for your passion in helping other people avoid your misfortune. And the same goes to the other 2 experts that we have here. Thank you so much.
And Jeffrey, hopefully we'll see you in real person next year. So
100%. As long as I continue to draw breath and I have my mental faculties, I want to continue on with this, tradition every year, participating in this program. And I do want to be mailed the medal and other accolades. It does make me feel good. It is healing. It means a lot sentimentally to me as well. And it's my life mission to do this type of work. And that's how I make sense of everything that happened to me. And that's what allows me to not lose my mind, honestly. But I have sense of purpose now. And, I take the energy that I would feel and I channel it into the advocacy work. And, that's how I'm not angry or bitter. I want to enjoy my life as much as I can. And I don't think I can do that if I'm angry or bitter. If I was to share a life lesson with everybody, not necessarily wrongful conviction related, but an insight gained from it, I would say take advantage of all the opportunities that are there in society. Opportunities are very limited in prison. I'm a dream chaser. I believe in that. I believe in setting goals, having a plan, working really hard to turn that dream into reality. I think it's better to try and to fail than to never embark on it. Don't be afraid of hard work. There's no reasons why you can't accomplish something. There might be reasons why you have to work harder. There may be reasons why you have special challenges to overcome, but there's no reason why you can't do something. Never give up. Just never give up. Keep going. Leave it all on the field, to use a sports terminology. And I hope that some of the people in tonight's program will, as far as audience members, will go on to do something in wrongful conviction, whether that's to become a lawyer, a paralegal, an investigator, to help exonerees reintegrate back into society. And that would, of course, involve the professions of, being a psychologist, being a social worker. Within the context of nonprofit organizations doing this work, there is space for other disciplines, such as doing policy work and fundraising and work on social media. And there's really not any limit. I mean, there's a lot of work has been, meaningful work's been done by podcasters, by documentary makers, by movie makers. Certainly doing investigative journalism is a direct way to get involved, to just write an article here and there. It's crucial to have coverage when the injustices are afoot. It's great to turn everything into a learning moment after an exoneration has happened and analyze what went wrong and write articles about what things need to be changed in the system to prevent injustices in the same way. And that all has its place. That should be done. But far more crucial is getting media coverage while a wrongful conviction case is still afoot. Often the key to somebody being exonerated is not the direct legal services. There's actually a civilian person who has little to no background in the law that takes an interest in a case and that helps build the bridge between that wrongfully convicted person and the ultimate legal professionals that are needed to address the case and get it back in court. So I want to encourage people to consider careers in this field. Certainly researchers. I mean, we had Marina, Dr. Sorochinsky, just speak a little bit unexpectedly tonight about her research. And, it's so important to do research because that provides the statistics that advocates such as myself utilize when we push for policy changes and we meet with elected officials. And, if nobody is doing that work, we're going to be working with old stats. We're not going to have anything to base the reforms that we advocate on. The best practices that Fabian spoke about earlier in terms of identification, and that I spoke about as far as false confessions. These aren't just reforms that we just come up with in our head and we just articulate because it's our theory. These are all backed by social science experiments, and that has to do with research. So even just doing expert testimony work in the area of confessions or identification, those are also disciplines that are part of this. Consider donating to Innocence organizations doing this type of work. For people that go on to successful careers not involving this, think about being, when you've arrived education and financially, think about being an advisory board member, think about being a board member. Why don't you think about being a prosecutor or being a cop or being a judge that does things the right way, that does uphold ethical standards and is wrongful conviction aware and very, very careful to avoid that. We need to have honest people in all those professions, because at the end of the day, we're not natural enemies. It's only when misconduct happens that puts us at odds. But really the commonality is that we're all working for justice. We're all trying to, find who is the actual guilty people and exonerate, the innocent. That's the bedrock principle of that. And in actualization of that, I have been able to speak in front of different police, in front of police academies, groups of police, and prosecutorial groups, and in front of judicial gatherings. And I think that it's really important to pitch the tent as wide as we can to bring everybody in and work for changes, and so it's only against rogue people in those professions. It's not against people in the professions just ipso facto, just because they're there. So I think that distinction is important.
As a former prosecutor, it was very important that you work for justice. And sometimes justice is getting the conviction. Obviously, many times it is. But if you're working for conviction all the time and not justice, that's where problems occur. So it's a mindset and it's an attitude. And I think young prosecutors need to be trained to view things differently so that they're looking to do the right thing in each case. That has to be the standard in front of them. Hopefully they can meet that standard more times than not. Well, I want to thank all.
I want to add, that in some.
Yes, go ahead, Jeffrey.
I'm sorry. I just wanted to add that some years ago there was a study by New York Times that reported that in all the exonerations that year, that in 25% of them there was some help by either the police or prosecutors at one point or another in the case. So a further illustration that it is possible to collaborate and work together.
Gentlemen, thank you all, ladies and gentlemen, both. This is very, very informative. It gave our students something to think about and a different perspective on this issue. And everyone stay safe, and hopefully we'll see everybody in the real outside world one of these days. So take care. Thank you. Carol, anything to add?
Thank you.
Good night now, everyone. Thank you very much.
Thank you so much.
Bye.
Any of our students wanted to stay on for ask a question in the class, just to us, that's fine. Everyone else, thank you.
That was a mess. They give you a trofeo, right?